Welcome back, dear students. Today we are going to learn the drafting of an application for appointment of receiver in a civil suit, and at the same time we will learn the appointment of local commissioner in a civil suit. So, dear students, first of all, you must know what is a receiver and how it is appointed by the court. Order 40, Rule 1 and 2 of CPC deals with the appointment of receiver, and the law is that if it appears to the court to be just and convenient, then court may appoint a receiver of any property, whether before or after the decree, or remove any person from the possession or custody of property, and thirdly, commit the same to the possession, custody, or management of the receiver. The purpose of appointment of receiver is the conservation and preservation of property and the rights of the parties or subject matter of the litigation during the pendency of the suit. Any respectable person can be appointed as receiver, including an advocate, retired judges, officers of the court. Advocates may be appointed as receiver. Even the collector of the district may be appointed receiver with his consent, where the property is land paying revenue to the government. This is the mandate of Order 40, Rule 5 of CPC. The receiver is to be appointed only for disputed property. Now, so far as the appointment and remuneration of receiver is concerned, the court may, by general or special order, fix the amount to be paid as remuneration for the services of the receiver in accordance with Order 40, Rule 2 CPC. Now, dear students, once the receiver is appointed, what are his duties? Following are the duties of receiver. Every receiver so appointed shall, first of all, A, furnish such security as the court thinks fit, duly to account for what he shall receive in respect of the property in dispute. So first of all, you must remember that receiver has to furnish security to the court. And secondly, B, submit his accounts at such periods and in such form as the court directs. He has to submit the accounts. Third, C, pay the amount due from him. If any amount is due from him, he has to pay that also. And fourth, be responsible for any loss occasioned to property by his willful default or gross negligence. Now, how do you enforce the duties of this receiver? Why this is important? Because you are going to draft an application for appointment of a receiver. You must know all these provisions. So if a receiver fails to submit his accounts in such periods and in such forms as the court directs, or if he fails to pay the amount due from him, or he causes loss to the property by his willful default or gross negligence, then court may direct that the property of the receiver to be attached, and he may sell the property of receiver also. And court may apply the proceeds to make good any amount found to be due from the receiver or any loss occasioned by receiver, and he shall pay the balance to the receiver. So it is the very onerous duty of the receiver. If he is causing loss to the disputed property, even the property of the receiver can be attached and sold by the court in accordance with Order 40, Rule 4 of CPC. Now, dear students, let us start the drafting of an application for appointment of a receiver in a civil suit. You see, civil suit is already pending, and you are moving an application that court should appoint a receiver in a pending civil suit. So name of the court will be the same where the suit is pending. You will have to imagine. So here in this illustration, I have selected the name of the court is in the Court of Civil Justice Senior Division, Noida, District Gautam Buddha Nagar, UP. Suit number dash dash of 2017. We have not mentioned suit number here because along with plaintiff, we are going to file this application for appointment of a receiver. So we do not know the suit number. Now, name of the parties are to be mentioned with full detail. Like our plaintiff, as usual, is A, son of B, aged about 40 years, resident of flat number 918, Pavilion Court 10, JP Greens, Wish Town, Sector 128, Noida, District Gautam Buddha Nagar, UP is our plaintiff, versus the second party is X, son of Y, aged about 45 years, a resident of flat number 509, Designers Park, Sector 62, Noida, Gautam Buddha Nagar, UP. So these are our names of the parties, plaintiff and defendant. Then center heading, application for appointment of receiver. Sir, you are addressing to the court. The applicant most respectfully submits as under. Para 1, that the applicant plaintiff has filed a suit for foreclosure of mortgage and sale of defendant's property in this honorable court. Para 2, that the defendant has intentionally damaged the property for diminishing the value of the property marked as Annexure 1 in the plaint. Para 3, that the defendant has taken 3 years advance rent from all the 5 tenants of the disputed property. Para 4, it is therefore most respectfully prayed that a receiver may kindly be appointed over the property in question and he be given the possession of the property, who will maintain the income of the property out of rent and will also maintain the property. This is a short application for appointment of a receiver. Signature of the plaintiff applicant are required. And since this application has been prepared and drafted by some advocate, so we are supposed to write down through ABC advocate, and signatures of advocate are also required. Then place of drafting, you will mention as Gautam Buddha Nagar, and date of filing this application is, say, 10 January 2016. So the nutshell idea in this application is that mortgagee is misusing the property. He has taken 5 years advance rent from the tenants and he is trying to diminish the value of the property. Property belongs to mortgager, not to mortgagee. So mortgager plaintiff is praying to the court that a receiver may kindly be appointed who will look after the property and collect the rents and profits from the tenants also. So this is a very short application for appointment of receiver. Moving on further, dear students, now we will start learning the drafting of an application for local commissioner. Who is a local commissioner and how it is appointed? So where the parties require for bringing before the court the actual condition of the property or the status of the property, presiding officer of the court cannot often go on the spot and find out the spot position. So for this purpose, the advocates generally are appointed as local commissioners. But what are the purposes for which a commissioner may be appointed? The first purpose is that commission to examine the witnesses within the local limits of the court for the purposes who are exempted from attending the court. Hello? Class में So first purpose is commission to examine witnesses within the local limits of jurisdiction of the court for persons who are exempted from attending the court or who is from sickness or infirmity unable to attend the court. This is mentioned in Order 6, Rule 1 of CPC, that if somebody is ill or is exempted from attending the court according to law, or he is sick or infirm, then for the purposes of recording his statement, commissioner may be appointed. Number 2, commission for local investigation for elucidation of any matter in dispute or for ascertaining the market value of any property or mean profits or damages. So for local investigation, generally, advocates are appointed as local commissioners. This is in accordance with Order 26, Rule 9 of CPC. Now, what is the procedure of commissioner? The commissioner, once he is appointed, after such local inspection as he deems necessary, and after reducing to writing the evidence taken by him, he shall return such evidence together with his report in writing, signed by him to the court under Order 6, Rule 10, Clause 1 of CPC. Now, what is the value of the report of the commissioner? Once local commissioner is appointed, he has visited the spot, he has prepared the report, he has reported the status of the property on the spot. So the report of the commissioner and the evidence taken by him shall be evidence in the suit and shall form part of the record. See the importance of local commissioner, advocate commissioner, that whatever he has reported and whatever evidence he has taken, that shall be evidence in the suit and shall form part of the record. Although parties can summon the local commissioner for cross-examination also, if allowed by the court. But the court, or with the permission of the court, any of the parties to the suit, I told you, may examine the commissioner personally in the open court, touching any of the matters mentioned in his report or as to the manner in which he has made investigation. You can call advocate commissioner or local commissioner for his examination in the court also and cross-examination also. And sometimes a second commissioner is also issued. If the court is dissatisfied with the proceedings or report of the commissioner, it may direct further inquiry to be made by the same commissioner, calling his additional report, or by a new commissioner also. New commissioner may be appointed to give his fresh report if the court is dissatisfied with the first report of the first commissioner. Then commission may be issued for scientific examination according to Order 26, Rule 10A, CPC, scientific examination. Suppose some machinery is to be measured regarding its capacity, if it is in dispute in a case. So commission may be issued for scientific examination, for measurement of that machinery, checking the power of that machinery, etc. Then number 4, commission may be issued for performance of ministerial acts. That is, an act, particularly of a government employee, which is performed according to law without exercising any individual judgment. So ministerial acts may be performed by the local commissioners according to Order 26, Rule 10B, capital B, CPC. Then fifthly, the commission may be issued to examine the accounts of a firm or accounts of a registered company. Commission may be issued to examine and report the status of the accounts, whether they are going in profits or they are going in losses, according to Order 26, Rule 11. Then commission may be issued to make partitions also. I told you earlier also that in partition suits, two decrees are prepared. One is preliminary decree and second is final decree. Preliminary decree divides the shares of the parties. It declares the shares. Suppose plaintiff has 1/4 share. Now commission has to be appointed so that he may go on the spot and demarcate 1/4 share by meets and bounds, or by raising the wall and segregating the 1/4 share of the plaintiff, which was decreed in preliminary decree. Now, according to partition done by the local commissioner, the final decree shall be prepared. And court can fix the time for return of the commission also. It's not that the commissioner gets the unlimited time to submit his report. So, dear students, the court issuing a commission shall fix a date on or before which the commission shall be returned to the court after its execution along with report of the commissioner. So local commissioner will go on the spot, will execute the commission according to directions of the court, and then the commission shall be returned after execution along with the report of the commissioner according to Order 26, Rule 18B, CPC. So dear students, with this background knowledge in mind, now we will start the drafting of an application for appointment of an advocate commissioner in a civil suit under Order 26, Rule 10, CPC. So first of all, the name of the court is to be selected as usual. In any drafting, you will have to select the name of the court first. So here in this illustration, the name of the selected court is in the court of this small causes judge, Karkarduma Court, New Delhi. SCC suit number dash of 2017. Plaintiff and defendant are A son of B, resident of 52 Lajpat Nagar, New Delhi is our plaintiff, and X son of Y, resident of 52 Lajpat Nagar, first floor, is the defendant in our case. So both the parties are residing at the same place. Ground floor, plaintiff is residing, and first floor, defendant is residing. Center heading will be drafted like this: an application on behalf of defendant for appointment of a court commissioner. The defendant above named submits as follows. Here the defendant is moving an application for appointment of a court commissioner. The defendant above named submits as follows. Number one, that the plaintiff has filed the present suit against the defendant for fixation of standard rent and recovery of possession. Okay. Para 2, that this defendant has accordingly filed his written statement separately and also an application for grant of stay order, that is temporary injunction. Para 3, that this defendant respectfully submits for the kind perusal and sympathetic consideration of this honorable court that the plaintiff says that area occupied by and in possession of this defendant is 900 square feet, while the actual area is 450 square feet approximately. Now, dear students, this has to be inspected on the spot by the local commissioner and find out how much area is in possession of the defendant, whether it is 900 square feet or 450 square feet only. Para 4, that this defendant also submits that with a view to confirming the actual area occupied by and in possession of this defendant, and also taking the measurement of the suit premises, it is indispensable that this honorable court be pleased to appoint a court commissioner. Court commissioner or local commissioner are the same thing. Para 5, that this defendant submits that the plaintiff has tried to mislead this honorable court by purposely mentioning the wrong area of 900 square feet instead of Actual area 450 square feet. Para 6, that this defendant submits that if this honorable court is not pleased to grant this application for appointment of a court commissioner, this defendant will suffer irreparable loss and damages because it has to be proved before the court as to how much area is in the tenancy of the tenant. Para 7, that this defendant also submits that unless the plaintiff amends the plaint itself by mentioning the area of the suit to be 450 square feet approximately, the true facts will not come before this honorable court. Amendment of the plaint will be required once the area is deciphered, and it has to be done by a court commissioner. Para 8, it is in the interest of justice that an advocate commissioner may kindly be appointed for this purpose, who should be directed to visit the disputed property in the presence of both the parties or their respective counsels, take the actual measurement of the disputed property, prepare its map on the scale, and also record the facts told to him by the respective parties. Para 9, that the disputed property in the first floor of the immovable property and as such cannot be produced before this court. Why there is a need of appointment of commissioner? Because the disputed property is located at the first floor of immovable property, 52 Lajpat Nagar, which cannot be produced before this honorable court. And last paragraph is a prayer. It is therefore most respectfully prayed that this application of the defendant may kindly be allowed in the interest of justice, and an advocate commissioner may kindly be appointed for this purpose, who should be directed to visit the disputed property in the presence of both the parties or their respective counsels and take the actual measurement of the disputed property, prepare its map on scale, and also record the facts told to him by the respective parties and submit his report expeditiously before this honorable court. Date of filing this application is 1/1/2017. Place of drafting is New Delhi. And the person moving this application, X son of Y, is the defendant. His signatures are to be obtained on this application. So defendant will duly sign this application, and you can say that since this application is drafted by some advocate, so we should mention in our application through counsel MNP advocate, and his signatures are also required on this application, like signature of defendant, signature of MNP advocate, or whatever his name may be, are to be appended on this application. So dear students, this is how we have learned the drafting of two applications today. One was for appointment of a receiver, and second for appointment of a court commissioner or local commissioner. So thank you very much, dear students.